May it please the Court, my name is Andrew Guzzo, and I'm here on behalf of the appellant Carol Robinson Huntley. Also here today is my co-counsel, Christy Kelly. I would like to reserve 2 minutes for a rebuttal. There are two issues before the Court today. The first is whether the trial court erred in excusing performance of Carver Mutual's contractual obligation in this case. The second issue is whether the trial court erred as a matter of law in concluding that Ms. Robinson Huntley was not adversely affected as required by 55-492 of the Virginia Code. Our position on these two issues are simple. The first is that Ms. Robinson Huntley and Carver Mutual entered into a contractual relationship which required Carver Mutual to make the repairs requested in this case. The second is that 55-492 does not require proof of an adverse effect as an element for a claim of attorney's fees under the statute. Rather, the language in the statute is a standing requirement which allows the person to bring a claim before the court rather than a disinterested person to come before the court. Once the violation is established under the statute, the party by definition is adversely affected. Beginning with the contractual issue, the crux of this involves the interpretation of paragraph 7.6 of the proprietary lease, which states that Carver Mutual shall provide and pay for Ms. Robinson Huntley's property, including her dwelling, except that she must make minor interior repairs. This lawsuit started after Ms. Robinson Huntley had requested several repairs to her unit, including her pipes and her exterior walls. After a 2-day trial, the court found that Carver Mutual was not obligated to make the repairs, even though Carver Mutual had stipulated to its responsibility and stipulated that the repairs were necessary. For 3 reasons predominantly, we would ask the court to reverse this decision. First is that Carver Mutual stipulated that both the repairs were necessary and that it was their obligation to make those repairs under the governing documents. Second, the plain language supports this interpretation. And third, any ambiguity should be resolved against Carver Mutual as the drafter of the governing documents of the association. I just want to take a minute to briefly run through each one of those. The stipulations by Carver Mutual were found at 139, 270, and 271 of the appendix. And all of these reflect that Carver Mutual acknowledged that the pipes and the exterior walls were both a problem and needed to be repaired, and that they fell under the jurisdiction of Carver Mutual under the governing documents. We believe this admission should have been dispositive, and this alone should have required the court to enter an order enjoining Carver Mutual to make the repairs. There is no language qualifying this obligation anywhere in the documents or making it discretionary when and how it can make these repairs. There is no textual basis whatsoever for the court to find that Carver Mutual was trying its very best or did not abuse its discretion. There is no such thing as discretionary enforcement of a contract once someone has the obligation to perform. I think the court was confused in this instance between a claim for breach of fiduciary duty. We never alleged that the association had breached its fiduciary duty or had a business judgment call that was an issue. It was purely contractual, whether they had the obligation or not. And on the second point, I think the plain language supports our argument. I think it's the court's job to give the language that was intended by the parties and is not at liberty to rewrite the contract in this instance.
Okay, counsel. Looking at your second and third arguments together, first, that the plain language supports your position. Second, that if there is an ambiguity, it needs to be read against the drafter. Let's presume there is an ambiguity. And as you go into the record, and if you need to, it's Joint Appendix page 292, I believe, the contract into your client's predecessor in interest had almost identical language, but with a significant difference. The language into your predecessor and your client's predecessor in interest said that Carver shall provide and pay for all necessary current repairs, maintenance, and replacements of the property, including members' dwelling, except the members shall make minor interior repairs and provide all interior painting and decorating. The contract into your client deletes all necessary current repairs, maintenance, and replacements, and also deletes painting. Why were those deletions made? And how do you, if you don't know why, how do you explain them?
To answer the first question, I have no idea why it never came up prior to the court's bench ruling. We never relied on the one document to prove the intent of the other document. We viewed them as separate. But in my opinion, the second document actually supports our position in two ways. The first is that the second part of the sentence is the most important part in this instance, and it obligates her to make the minor interior repairs. It sets out her obligation, and the beginning sentence sets out Carver Mutual's obligation. And I think by virtue of keeping that language in there, that she shall make minor interior repairs, the first sentence, now that Carver Mutual must pay for property, you can still read in repairs to the property. And secondly, I think the deletion renders it ambiguous. We have no idea why it was deleted. It's my understanding that Ms. Robinson Huntley should have inherited the interest that her predecessor had. Now, they signed a different contract, but the contract still requires her to make minor interior repairs, and the association needs to provide and pay for the property. And I think under the term property, that's a pretty broad definition, and in our brief we cite Black's Law and a common sense in this instance. I mean, the whole purpose of this association is it's a common interest association where you pay for some things and some things you get back. And if you look at Article 9 of the bylaws that was in effect at the time when she signed it, it says that her payments are going to the reserves to build the exterior. So I think any ambiguity, you look back and you can look at Article 9 of the 1989 bylaws and say, I'm paying my money and this is what we're getting.
Okay, Counsel, again, presuming ambiguity, and I know you argue that there is none, we can also look at the conduct of the parties. What other interior repairs did Carver make to any other units within the development?
Just one point of clarification on that question. I think both of the repairs in this instance, pipes and the exterior walls, are exterior repairs. And therefore, we're not dealing with interior repairs, and that was never really the focus. There was instances where there was gas leaks, and Carver Mutual had repaired gas leaks. There was instances where they had repaired canopies. This suit was actually originally filed also to get her canopy repaired, and during the pendency of the litigation, Carver Mutual actually repaired the canopies, repaired them for all, but did repair her canopy. But as instances of interior repairs, that was never really a focus because both of these, in our opinion, were exterior repairs.
Were these the pipes that were keeping the sinks from working?
They were causing sewage backup and other leaking.
But they were between her wall and the next unit's walls?
Correct.
And you're calling them exterior repairs?
Exterior repairs, they were referred to as exterior repairs during the trial by by Alvin Richardson, who is a member of the board of directors. It was also stipulated to that at the end of the trial that these were within Carver's jurisdiction and needed to be repaired. And once Carver stipulated to this, I just don't see how the court could say they didn't need to honor their obligation.
Well, again, we're trying to figure out whether there is an obligation or not. Now, if you've got interior on one side, something that is clearly interior in her kitchen, something that is clearly exterior in a common area, precisely where does the line get drawn between interior and exterior under the documents? Either the contract, the bylaws, any of the governing documents?
I don't think any of the governing documents really address that, but the way it was discussed at court, and I think the way it's looked at under the definition of the statutes, is that a common element is anything that adjoins two units. And in this instance, Ms. Robinson-Huntley's pipes were not only having a problem, but her neighbors were too. And the plumber who came to look at the pipes said that it needed to be dug up and that the pipes were actually underground. And once the underground pipes. And so once that was established that it wasn't within the parameters of her walls, I think that makes it an exterior repair.
And what in her contract allows her as an individual unit owner to, and I use the term unit owner, understanding that it's not a condominium, but this is the first such case that I think that many of us have dealt with. So that what is it within her contract as an owner that allows her to force exterior repairs that benefit the entire regime?
I think it's the use of the word shall provide and pay for property. I go back to that. But I also go back to the common sense and the purpose of this association. She doesn't own title to her individual unit. If you go to land records, you're not going to find her name anywhere. The unit is owned by the cooperative.
Okay. Again, I go back to the beginning of your answer. Precisely what is it in her contract? If for example, the roof over the hallway was leaking, what in her contract would permit her to say, you've got to fix that roof, or you've got to fix the broken sidewalk outside, or you have to fix the pipes under the common area or under somebody else's unit, because all of those are affecting how I live within my unit? Just point me to this precise language that permits her to do that.
To file a suit against the cooperative?
Yeah.
I don't think there's anything within that document that says you can file a lawsuit against us. I think you could look at 55-436 under the Virginia Cooperative Act, and that says the statute needs to be liberally administered, and any violation of the statute or the bylaws, I think, allows the party to come into court. But it's just a basic contract theory. The parties have a contract in this instance. They both sign their name to a piece of paper.
You did not file suit under the statute, though?
Not in this instance. Just real quick on the second issue before the court. The court denied Ms. Robinson-Huntley's request for attorney's fees, finding that she did not prove that she was adversely affected. We think this was an error because the word adversely affected allows the person to come into court on a claim. Adversely affected is not defined in the statute, so you must apply the plain meaning. And I think the cases of the Board of Supervisors versus Board of Zoning Appeals of Fairfax County are instructive on this instance, talking about the difference between an aggrieved party and an aggrieved party. And I think the whole analysis of these cases is standing. And I think the definition of aggrieved and adversely are almost synonymous, and the distinction between these is immaterial. And if you look at 55-436, it actually uses aggrieved party, and I would submit that both of those are the same under the statute.
But this says that you have to have been a person that fails to comply with the provisions of the Declaration of Bylaws. So she has to be adversely affected by a violation of the bylaws. And
the claim that we were successful on in this lawsuit was a conflicts provision that was entered into the bylaws, the 2011 bylaws, and the court ultimately struck the bylaws. And one of the arguments during that was that the bylaws did not give the association the authority in this instance to enter into that. And so once the court struck a provision in the bylaws, we believe that makes it within 55-492.
But, counsel, your argument that you were adversely affected was under the contract.
I don't think you can read the two of them independently. They use the bylaws to overcome the contract. It was a mechanism in the bylaw to overcome the contract. They tried to take away everything that she had, the minimal rights that she had, by a provision in the bylaws.
But the point is, the relief that the court gave you under the bylaws with regard to their violation did not in any way relate to the adverse effect from the plumbing. In other words, by the court making its order on the bylaws, the plumbing was completely independent of that, correct?
Yes, Your Honor.
So how did you prevail on the issue on which you were adversely affected?
We prevailed by, and I see my time is up.
You may answer.
We prevailed on striking a bylaw, and they used the bylaws as the authority to make this provision, and we prevailed in striking this and keeping the contract intact. And I don't think you can look at them as totally independent of each other. They're interrelated, and in this instance, the effect of the bylaws was directly in question.
Thank you.
Thank you.
May it please the Court. My name is Patricia Fettman. I represent George Washington Carver Mutual Homes Association. It is the oldest wholly owned African American cooperative in the United States. Understanding the foundation of the cooperative and its members is integral to putting the trial court ruling into perspective. The cooperative was created by those families who were displaced from their homes in 1941 when the land was taken for the construction of the Pentagon. The association itself was created in 1949 by the same families who had been displaced. So you had the families creating the association, borrowing the money to purchase the housing project from the federal government. Therefore, you had the same individuals both creating the association, being the association, and in 1949, when the first mutual ownership contract was signed, they were also the ones who drafted the mutual ownership contract. So in terms of asking the court to interpret the mutual ownership contract against the association, there's no evidence that was ever presented before the court of who drafted the document or the amended mutual ownership contract. This appeal comes before the court on the two assignments of error, the first one being that the court erred as a matter of law in excusing a contract performance of a recognized obligation. At no time did the trial court excuse any contract performance. Rather, the court refused to grant the appellant's request for preferential treatment. The trial court's decision must be considered in the context of the undisputed evidence presented at trial. 1. Prior to the lawsuit being filed, Arlington County Housing Authority had completed an engineering survey. It had determined that all the units had problems with roof, canopies, permastone, electrical, and plumbing. Prior to the lawsuit being filed, the members of the cooperative had voted to increase the monthly dues to pay for these items. Prior to the matter coming to trial, the cooperative had completed repairs to all the canopies and all the roofs, including that of the appellant. The trial court was not excusing any contractual obligation under the mutual ownership contract. The court found that there was no basis for it to order the association to repair her unit simply because she had asked for it. In terms of the repairs, this lawsuit started with the appellant asking that because she had clogged pipes, asking the association to repair the exterior sewer lines, which the association has never denied or changed its position that the exterior sewer lines are the association issue. However, the association said, we've always been able to correct that problem of interior clogged pipes with Simply Plumbing. It is your responsibility. It has been the historical obligation of all the members, and at no time has the association ever done interior repairs. And they provided her the name of the plumber who had always done those repairs. And before the lawsuit was filed, the appellant, in fact, had her clogged pipes repaired, and the unit was functional. This would have cost, even though the appellant says this cost only $6,000, it would have cost the association $130,000 unless it gave her preferential treatment. Because the entire association, this was a housing project. The association did not have the funds. It would have been using 50% of its reserves for that. the court clearly found on the issue of whether or not the co-op is required to make the repairs to her unit. I don't agree that they have to do it, and this is strict looking at the contract, but in conjunction with the bylaws and the operation of this organization. I don't think the plaintiff has submitted enough evidence to me to show the co-op has essentially ignored the problems at the co-op or abused its discretion in the way that it managed its affairs. For example, I think Ms. Robinson-Huntley might have had a case if they had repaired everyone else's unit but not hers. But I think the problem that every individual member of the co-op has in this case, and I should say in this situation, she's the only plaintiff here, keeping in mind that this is not a derivative action. She's not asking that all the units be repaired so that everybody be treated equally, but she's asking for preferential treatment. She's the only plaintiff here. An individual plaintiff who has come before the court is that they're also the co-op. So the members themselves are the co-op, and the co-op is the members, and they have to behave in a manner that's consistent with the best interest of the co-op and the body. It is our position that at all times she has been asking for preferential treatment. One of the arguments made by counsel is that the co-op, the association, could borrow the funds. However, this is contrary to both the bylaws and the mutual ownership contract that clearly says that the reserves, everything needs to come from the members themselves. There was substantial testimony at trial of the fact that these are the original families that were in the housing project at the time that it was created, that if the association tried to raise sufficient monies to make all the repairs that are necessary, that the members would not, many members would not be able to afford to do this. In fact, the members have been there so long that the current president of the association was herself one of the original incorporators of the association. Therefore, it's our position that the argument ignores the bylaws and the mutual ownership contract. This brings me to the second assignment of error, which is more complex. Appellant argues that the trial court erred as a matter of law in determining that appellant was not adversely affected as required by 55-492 with the unilateral removal of contractual rights through an amendment of the bylaws. This misstates the court's ruling. The court found that she was not adversely affected by the failure of the association to appoint a finance committee. The court stated that she was not harmed in any of the other actions. At no time did the appellant argue in the lower court or suggest to the lower court that the striking of the conflicts provision, which is your standard conflicts provision that says in the event of a conflict between the bylaws and the mutual ownership contract, the bylaws prevail. This is almost identical to the clause contained in the mutual ownership provision, mutual ownership contract itself, which says that the member agrees to abide by the bylaws, the declaration, the mutual ownership contract, and any amendments to the bylaws. We were simply confirming what the mutual ownership contract stated. The association did not appeal the decision because it did not want to be spending any more money on this case. Counsel argues for legal fees. He argues that because he's making an argument under 55-492, that immediately qualifies him for a finding of adverse effect. Of importance is the fact that the second count, this was a 6-count complaint. The first count was that appellant had been denied access to the financial records. The court said no, and he did not appeal that. Count 2 was the original bylaws and the 1989 bylaws. Both stated that the association was to do a CPA audit. Because the association was contemplating the sale of the land, because the $3 million price tag that had been placed on the property for rehabs was insurmountable, the association had always planned, 5 years before the lawsuit was brought, to amend its bylaws to facilitate the selling of the land to a developer. When the appellant files suit against the association, claiming that she was adversely affected by the failure to do a CPA audit and suggesting a multiple of motives, negative motives on behalf of the association, we pointed out to the court that never in its then 63-year history had the association ever done a CPA audit, even though the appellant herself had been on the board of directors. Never had she asked for a CPA audit. Prior to the filing of her lawsuit, she had never asked for a CPA audit. That did not stop her from filing a lawsuit demanding a CPA audit, saying that she was adversely affected, and asking for $100,000 of punitive damages and legal fees because of her adverse effect. Your Honor, in this case, you've got the statute requires adverse effect, and if I may quote from the court's ruling, which specifically says, I don't believe that she's been harmed by the conflicts provision. The conflicts provision struck the clause that was in the amended bylaws. Therefore, there was no violation of the amended bylaws. There was never previously any suggestion that the mutual ownership contract was a proprietary lease. And in fact, the court was very specific in stating that she wasn't the trial court held that she wasn't sure whether or not she could even rule on the conflicts provision because there hadn't been any issue that was appropriate for the conflicts provision. The only thing the court found was that there was a possibility that it could create a conflict between the mutual ownership contract and the bylaws, and that because the parties had each spent in excess of $60,000 to bring the multiple counts before the court, she felt it was her duty to give the parties guidance. Not that it had made any difference to date, so that there wasn't any adverse effect shown, but she wanted to avoid an additional lawsuit. In addressing the issue of legal fees, counsel asked this court to award him $60,000 worth of legal fees, even though he lost on 2 counts. He only won on 2 technical counts having to do with the finance committee and the striking of the conflicts clause, and he appeals on the 2 counts which was for the declaratory judgment and the injunctive relief, both which deal with the repairs to the appellant's unit. The court ruled, I don't believe she's been harmed in this conflicts clause. I don't think she's shown any harm. I don't base my ruling on the injunction on that conflicts clause provision. I ruled against her on the disclosure of documents, and while I agree that the finance committee needs to be established, Ms. Robinson-Huntley has shown absolutely no adverse effect from that having not been formed nor in performing its duty. So for all these reasons, I don't see any reason to award legal fees. This court has the statute, the last sentence of 55492A specifically provides that in an appropriate case, the court may award legal fees. The trial court was very articulate in explaining why this was not a case appropriate for legal fees. At trial, at no time did the appellant make any attempt to distinguish in her submission of legal fees what fees were related to the counts that she lost. Twice she amended her complaint on the audit requirement, and for the request that she be permitted to have legal fees or that the repairs be done to her unit is contrary to the evidence presented at trial, and we do ask the court not to grant the appeal. Counsel did raise the issue of impossibility of performance, but this was rejected for certiorari by this court, and therefore I will not be addressing it, and I see my time is up.
Thank you.